Have you really thought through the process of appointing your executor or your power of attorney or your healthcare directive? These should not be careless appointments. You should pay attention to how a person behaves in crisis. You should consider whether or not that person is selfish and only looking out for themselves. You just need to simply consider that your favorite person is not necessarily a favorite of theirs, if that makes sense. I am Stephanie Graham. I am a probate and estate planning attorney, and it is my job to keep your family out of probate court and craft and customize trust plans to keep your assets in your family for generation after generation to help you create a legacy. But I got into this field of law because I worked in banking before I attended law school for almost 7 years. And we had 2 incidents where we had older customers who came into the bank one day and discovered that their accounts were completely wiped out. And who did they name as the power of attorney that prevented us from helping them at all? Their favorite grandsons. And this incident happened well over 20, 30 years ago. Yes, I'm dating myself because you won't believe my age anyway. However, just recently on the news in Georgia, I think less than a year ago, there was an elderly couple in their 80s who gave power of attorney to their grandson because they needed funds. I could not obtain the information on the website for the full story because I imagine there was a subsequent lawsuit, but I couldn't imagine why an 80-year-old couple who already owned their home needed funds. I don't know if they told him to sell the house, but they ended up on the news because their testimony was that their grandson sold their home right from up under them. And they had lived in that home for 40 years. But that's because they chose their favorite grandson to be the power of attorney. And just because that person is your favorite does not mean that they have your best interest at heart. And there is nothing any attorney or law enforcement can do because you gave this person full authority to be your power of attorney. Now, you should be the power of attorney of your minor children because once they go off to college, they might need your assistance in depositing their checks or withdrawing checks. If they have a medical emergency, the school is not going to contact you because, yes, they are considered adults now. Now, I know there are minor opinions, and I don't say minor, I guess there's a minority opinion where some folks said, let the kids grow up. That's all fine and dandy. This is not about the kids growing up. This is about your 19-year-old suddenly convulsing and having a stroke or a eurythmia where their heart stops and no one will call you because they're an adult. And that's not a situation that your child can help themselves out of. So we're not talking about powers of attorneys and healthcare agents for able-bodied adults, including 18-year-olds. We're talking about people who are incapacitated for a limited time because they have a stroke, they have an accident, their heart stops. That is when you want to ensure that you have a power of attorney as well as a healthcare directive in place because that will allow the school to contact you. And some colleges have their own documents in place to allow you to do this. So yes, let your kids be a grown-up. I should have allowed mine to be more of a grown-up and more responsible when she was younger. However, if my daughter falls head first onto the concrete or she passes out, I would love to have somebody contact me. Wouldn't you? Leave me a comment below and let me know your thoughts. You can follow for more, and don't forget to protect your legacy and have that conversation with your agents.